All right, everyone, we are back. Make sure your cameras are on. Sorry it took a little bit longer. I thought I'd lost someone. Check in, check in. Amira says we don't mind the extra 5 minutes. Okay. Come on, everyone, check in, please. Mm-hmm. Mm-hmm. All right, cool. You guys ready? Let's continue. We got only a few pages to go, so hopefully we'll leave early. Right, Amira? Just for you. There you go. All right. So involuntary title transfer. Involuntary. Involuntary means forced, against your will. Correct? Make sure you put your phones away and your focus here. Thank you very much, everyone. At home and in here at the school. All right, so involuntary. What do we know about involuntary? You guys already know that if you have no will, right? Laws of descent take over. Hey, Dahlia, what's up on YouTube? And Sanam, yes, right now I'm only doing Monday through Wednesday. And the following classes, I'm probably not going to have them on YouTube, depending on the instructor that I bring, because I'm going to be out for a couple of months, okay? So Sanam, now is the time to pass. All right, so again, laws of descent, no will, abandonment, you abandon the property or the claim. We'll talk about that better in a little bit. Foreclosure, everybody's know. Unpaid. Oh. Right? Monifa says, you got financial freedom? I want that, Bruno. Well, in this case, it's forced vacation. I'm going to go for a surgery. So, but yes. Luckily, I'll be able to be okay while I'm home. Eminent domain, government takes. Thank you. Adverse possession, squatter's rights. So somebody else takes, right? Squatters is somebody that steps into your property without your permission or uses your property without your permission. Uso capião in Portuguese, yeah.
The one we talked about yesterday.
That's what it is. All right, and then we have Estoppel. I'm going to explain when we get there, so it's easier. So both of these I'll talk about later. So laws of descent, foreclosure, eminent domain, and adverse possession. These you should be familiar with already, right? Let me repeat that. Laws of descent. You don't have a will, no heirs, government takes. Foreclosure, you don't pay your bills, right? and the bank or the city comes and take your property for unpaid taxes or mortgage. Eminent domain. It says here the government takes. The government needs your property for certain reasons, for the greater good, right? And adverse possession is me taking over your property, right? Either the whole property or part of it, because you didn't say anything. So I just took over, right? Thank you, Dali. I appreciate that. I miss you guys too. But you guys got my number. I'm not going to be stopped. So if anybody has questions, even if after the surgery, if you have questions, just reach out to me. That's all. If you call me every day, I'm going to block your number.
Ask you about the book.
First of all, no calls. That's the first rule. You should know. No calls. Send me messages. WhatsApp, email, as many messages as you can, questions, all that good stuff. A call is always met with crickets on the other line. June 2nd, supposedly. I'm still waiting on the confirmation. Philip says, I didn't sign up for another teacher. Well, the one that's going to do the remaining of this course is the morning instructor, and she's pretty awesome too. And this is me considering that I'm awesome. But she is pretty good. Okay? I vouch for it. Okay? All right, so let's go over this. Laws of descent. It's involuntary alienation. You guys already know what the word alienation means, right? Transfer property to somebody else. Okay? If I'm on the deed, I'm the owner, the resident, the citizen, right? Everybody else that's not on the deed is an alien. So alienation is when we swap places, transfer to somebody else. All right? Now, in the laws of descent, this alienation happens when you die without a valid will. Okay? And it says right here, in absence of heirs, the title transfers to the state or county by escheat. Now, abandonment. Did you guys know that abandoned or vacant property, the city can show up and say, well, this is deemed abandoned. Here's a notice to the last address on record. If nobody responds after a certain time, it also escheats or reverts to the state or county. So the city, the county, or the state can take over the property because you abandoned. So guys, if you have property in another state or a property that's far away from you, even in the same state, make sure you maintain the property. Okay, there's a lot of property here in Newark, for instance. There's over 1,600 properties right now in Newark that belong to the city of Newark. The majority of them are for non-payment of taxes, but there's a large portion of them that are simply because they're deemed abandoned. Right? And the city at one point, you get to the point where you're not paying taxes, and the grass keeps growing, or you can clearly tell that's not being maintained, and the city says, well, if nobody shows up, we gave them 90 days or 180 days or whatever it is in your area, right? Nobody shows up, we take over. That's it. Good luck. Foreclosure. Can you fight the government to get the property for yourself? That already says it all. You already put so much effort in asking the question. Can you fight that already exhausted me right there. Fight the government. That's a different story. If you found it first, make sure you maintain it right away so they don't come.
No, I'm not saying I found the owner.
Maintain it right away so the government doesn't come. Yes. All right, Philip, escheat just means the government takes over. Yes. Yep. Now, foreclosure, you fail to fulfill your loan obligations or pay taxes, and they just you lose the estate through foreclosure. All right, Jose. So is cheat usually, if we're talking about descent, let's go back here. If we're talking about descent, is cheat is you're losing because you don't have a will. But if you abandon the property, it's also called as cheat when it goes, every time it goes to the government. So if you lose the property because the government gets it, right, it's called as cheat. Okay? The only time that it's not considered as cheat is with eminent domain, because eminent domain, there's kind of like an agreement between us somehow. So as cheat, they take over. Eminent domain, they tell you they're going to take over, but they compensate you for it, right? So they give you some type of compensation. But yes, for state exam, remember as cheat, no will. That's the easiest way to remember. But if you see the word reverts to the state, it's also no will. Okay. A second. Losing battery. Dropping 6%. All right. We got this, right? 6%. We got this. All right, real quick. So eminent domain, they take your property for public good. You guys already know this. Adverse possession, we talked about it yesterday. Hold on. Amira says reverse to the state means no will. So that's what I was saying. If you abandon the property, it's also called reverting to the state, because all property pretty much belongs to the government, right? If you're paying taxes, it's because it doesn't belong to you. You're renting. That's what taxes are. You're renting a property, right? So even though the title is yours, you still pay taxes, right? So Amira, whether it's abandonment or descent for having no will, right? Either one of these two, you abandon the property or no will. Either one of these two is called reverting or is cheating to the government. Right, Wendy? Right? Okay, stay with me. Kick everybody else out. You already missed a couple days. By the way, I'm notorious for calling people out. I'm sorry. Right? Mm-hmm. All right. Dahlia says, I don't like to interrupt your classes. Plus, barely, I don't have any questions, since you explained good enough to understand. Perfect. But if you do have questions, whether during the class or after class, reach out to me. All right? WhatsApp is my preferred method of communication. So just reach out there. All right. Adverse possession is squatter's rights. You guys know this, right? And to claim legal title, the adverse possessor must be able to show claim of right or color of title as reason for the possession, have notorious possession, which is possession without concealment, maintain a consistent claim of hostile possession, which is a claim of ownership regardless of owner's claims or consent, occupy the property continuously for a statutory period of time, and in some states pay taxes. So in some states, for you to claim adverse possession, for you to claim somebody else's property, you also have to be paying taxes. Okay? Not all states require this. So what are the rules here? Open, visible, and notorious. Everybody knows that you're there, right? Adverse or hostile takeover, meaning without permission. Simple. You do this, and the property could become yours. And also, whatever the period of time.
What taxes? Property that you want to claim, or your own taxes?
Well, property, obviously. The property you're trying to claim. Your taxes better be right, too. All right, claim of right and color of title. What's the difference between these two? Claim of right means you took over the property by trespassing, right? But claiming that legal adverse possession by following the procedure. Color of title is a little different. Color of title means you received a title. Means I sold to you, but the property was not mine to sell. Okay? There was an issue with the property when I sold to you. Okay? So let's say now I correct the issue and I ask the property to come back to me. Can I do that? Can I sell to you and then say, oh, there's a mistake, bring it back? I cannot. In fact, a court may hold that the claim of right or claim of colored title is valid reason for the possession. Simple. Okay? Philip is asking, how do you pay taxes if you don't have the deed? My man, listen, to pay bills, nobody asks questions. You want to pay my bills? Nobody's going to ask if you're the owner or not. How do you pay taxes if you're not the owner? A payment is a payment. Simple. All right. Notorious possession I already claimed. That's make sure that everybody sees it. It's visible. Hostile, without permission. You guys already got this. How do we avoid adverse possession? Well, check the property. In Florida, 6 years, right? So once every 6 years, or right before the 6-year period, show up, check the property, kick everybody out, whoever's there, and boom, you avoid it. State of New Jersey, once every 20 or 30 years, show up, see the property, kick them out. That's it. All right? And then this word, estoppel. Okay? Estoppel stops you from doing something. I'm going to explain what it is in a second. Okay? So there's estoppel in mortgages and there's estoppel in title. Estoppel, hold on a second, don't permits. I'm sorry, Jose, I did not understand your question there, Jose A. Or your statement. Don't permit easement by prescription. What do you mean? Oh, you go there, you show up, and if you stop them from being there, if you kick them out, it stops the easement by prescription immediately. So whatever the time period they claimed, when you show up, it kicks them out. Yep, that's right. Sorry. All right. So estoppel, there's estoppel in mortgages, there's estoppel in title. Estoppel means it stops you from a claim, okay? From doing something. In this case, it stops you from claiming something. So estoppel prevents a person from claiming a right or interest that is inconsistent with the previous person's statements or acts. So again, if I sold the property to you and there was issues with the title, right? Once I correct the issues, can I say, hey, give me the property back because I didn't transfer to you properly? I cannot. So an estoppel disallows the grantor's claim because of the prior conveyance action. Okay? Because I already transferred it, it is now yours. I cannot claim it back. So anytime there's a transfer, just like in mortgages, they sell the mortgage to a bank, to another bank, to another bank. The previous bank cannot come and foreclose on you, right? You are stopped from that claim. If I sold to you, can I claim the property? No, it's now yours. So that's what it is. The grantee or the buyer remains the legal owner and benefits from the clear title as well. Any questions on this?
And what does the cost of the estoppel to happen? In what the scenario?
Hold on, trying to check here. What causes the estoppel to happen? When I transfer something to you. As soon as I transfer the title, I'm stopped of the claim. I sold it to you, didn't I? Can I come and claim the property?
No,
It's yours. That's it. I'm stopped.
Oh, okay.
That's what estoppel means. Okay? Alright, hopefully the tablet will not die and we'll be able to finish it. If it does die, then we'll switch to another way of doing it, okay? That is charging, but apparently not enough. Alright, so title records. There's something called chain of title. Guys, what is a chain?
It's tied to you.
It tied to you? Okay, what else? What is a chain? I don't know what that is. Chain. What is a chain?
Stuck to you forever.
Stuck to you forever is a chain? Okay. Stuck to you forever. No, that's change. Talk about chain right here, chain. All right, Amira and Philip for the win. Link, right? Link. So it's what links, or continuance. So it's what links. In this case, chain of title is what links the current owner to the following owner, and the current owner to the previous owner. So it shows the chain of title is I sold the property to Eric, Eric sold the property to Elsie, Elsie sold it to Francis, and so on. And my tablet just died. Okay. Switch this real quick, guys. Give me just 1 second. We're going for the backup.
Mine tablet here. And what yours has.
That's the problem.
Do it airdrop.
That's an iPhone.
Oh, he is a tablet.
I don't play with those things.
I forgot on it all.
Android. All day, every day.
No discrimination. I work in a cell phone store, so I can take sides.
Alright, sorry, just give me 1 quick second so I can go to this backup. I think it's time to order that new tablet. It's too old already.
Did we talk about records yesterday?
Briefly.
Oh, okay.
We did talk about records briefly. All right. Okay, for you guys it's set. Right, and now I need for you guys here. Just give me 1 second. All right, so it's going to be a little weird for you guys. Because the only way to see it is like this. Okay, so if you want to get closer, you can get closer because that's going to be a little smaller. Just saying. Just a little bit smaller. All right. So like I said, what is a link? Hold on, Jose, I had understood estoppel was something that allowed to see a balance on the mortgage or a debt. So like I said, there's a estoppel for mortgages, there's a estoppel for banks. Estoppel for mortgages is where the transferring bank, let's say I'm Bank of America and I'm selling it to Chase. Bank of America has to give a balance on the mortgage and settle for that. So when I transfer to you, if I make any mistakes on that balance, I cannot claim anything else. I lose. All right? If there's any issues with the loan, I'm stopped of any claims. Same thing for title. When I sell to you the house, right, it does the same thing. It stops me from claiming, regardless of any issues that are there. Okay? So my claim stops at transfer. That's estoppel. So you're right about what you wrote when it comes to mortgages. Okay? All right. So chain of title. Yep, correct. It's just a stop. Chain of title has to do with link of title. What connects the current owner to the previous owner, right? See? Can you read? All right, so state laws require that the recording of all documents, as you see here, that affect the rights and interests in real estate and public records of the county where the property is located. So what we're saying is that pretty much if you want to protect yourself, state law requires that the documents are recorded. Public records, right? These public records or title records contain history of every parcel. County records or property records or title records contain history of every parcel of real estate in the county, including names of previous owners, liens, easements, and other encumbrances that have been recorded. And other encumbrances that have been recorded. Next page. Deeds, mortgages, liens, easements, and sales contracts are among the documents that must be recorded. Other public records that affect real estate title are marriage, probate, and tax records. If you guys notice from what it says here, other public records that affect title are marriage, probate, and tax records. So usually these are not recorded in public records. Like taxes, it's not against your property, but the city has a tax bill for you. So it is against your property, but it's not recorded against it. It's automatic, it's there. If somebody's married, you guys already know, if you're married, the spouse might have a claim on the property that you're selling. And probate creditors might have a claim on the property that you're inheriting. We just covered that. So these are not public records. Deeds, mortgages, liens, easements, and sales contracts could be there. Now, generally, a county recorder's office or similarly named office maintains the records. And title records serve a bunch of purposes. Not the least of which is to avoid ownership disputes. So why do we put stuff into public records? To protect your presence in the title and potential ownership disputes. Potential ownership disputes. All right. Other important purposes are for public notice, right? And you guys already know this term. You remember this. Constructive notice, right? What is constructive notice and what is actual notice? Who remembers? Constructive notice, actual notice. Who remembers this? Actual notice versus constructive knowledge. Notice. Philip wrote legal knowledge notice.
And how you left the claim.
Say louder. Constructive as you can find it. What about actual? Anybody?
Left the place.
Are you left the place? No.
The property.
Nope. 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 Notice. What is notice? Notice is information that's being given, right? It's either available or you received. So it's disclosure. Okay? It's an announcement. It's a warning. It's here, right? So actual notice is what you actually know because you did research. Constructive notice, information is available. Okay? Information is available is constructive notice. Information I actually know because I researched, it's actual notice. Okay? Like right now, I just noticed that Monifa and Amira are in the same room. Do you guys have just one speaker? You have both speakers? Does it do an echo? Or how does that go? I just noticed from the different angles, there's something in the back. No, I know it's two different computers, but do you have the same, just one speaker playing, or you have, it will be messed up to have both speakers going. How did I notice? Right behind you, there's something standing. Right there behind you, over your shoulder. And then at the corner on Monifa's background, it's the same thing. A stick. There you go. The broom. There you go. All right. The broom gave it away. See, the information was there. It was constructive notice. You guys put the broom there. But now I actually know because I noticed. There you go. Philip is like, your glasses are good. Yeah.
Are those made for Superman?
Imagine when I take them off.
My goodness.
Yeah. Oh, show off. Now you have to show up in her camera. I see you now. There you go. Mighty specs. There you go. Dahlia, correct. Actually, no. That's actual notice. Very good. But constructive notice is just information that's available. That's why we record stuff into public records. So when somebody goes search the public records, they will know who owns the property or anything against the property. Now, why do they do that? Exactly for this. It's called buyer protection. A buyer, when they're buying a property, they want to make sure that the seller can sell, and that's called a marketable title. Marketable title means that it's sellable property. Okay, there's no issues with the title. So why do we do constructive notice? So that when the buyer wants to buy a property, they can check the title records and make sure that the title is in fact marketable, sellable. Okay? Also, for lien holder protection. See, a lien holder, by the way, who can be a lien holder? Anyone? Like anyone who? Marlon says banks, Philip says banks. Who else could be a lien holder? Say it again. If you did work there, so if there's a mechanic's lien, right? Guys, anytime there's a financial claim or debt that's not paid against the property, they have a lien against the property. So lien holder is anybody that you owe money to and that use the property as security. So why do we have lien holder protection? Because if car dealers as well, they put a lien against the car as well. Lady Ann is watching on YouTube. Very good. Lenders, yep. So why are they protected? Because if I go buy your property, I'm going to see that there's a mortgage. I'm going to see there's a construction lien. I'm going to see there's foreclosures. I'm going to see whatever's happening, right? And it protects me, the buyer, but also protects the lender or the lien holder from you selling the property without paying them. Got it? So lien holder protection, they registered their claim. And yesterday, guys, we talked about this, the priority, right? Who gets paid first in the event of foreclosure? What type of taxes? Real estate taxes, not just taxes. Real estate taxes get paid first. All right? Everybody's celebrating at home. I love the little dances. Like, yeah. All right. So anybody that has a lien must get paid if there's a foreclosure or if there's a sale. This is why we do title searches. This is why people record stuff to say, I'm here first. The same way that my name should be on the property if we're married and you're trying to sell the property by yourself, right? I have a protection, and so on. So, chain of title refers, please highlight this if you don't have the PDF. Chain of title refers to succession of property owners of record. So again, what links one to the other, to the other, to the other. And this is dating back to, sorry, trying to zoom in enough. Right there. Dating back to the original grant of title from the state to a private party. And if there's a missing link in the chronology of owners, or if there was a defective conveyance, the chain is said to be broken. So think about it having a necklace. Necklace is composed of several chains, right? When you have a necklace, right? If one chain breaks, what happens to the necklace? It falls, right? Here's the same thing. If there's a link missing, then the chain falls. And there's potential lawsuits because now I do not own the property because somebody did not record the transfer at one point, right? So, to remove the cloud, the owner must initiate a suit or lawsuit to quiet title. Okay? It's called lawsuit to quiet title. And that clears the title records of any unrecorded claims. All right, next we have abstract of title. What I want you guys to remember here in abstract of title is that abstract, let me zoom in. This word right here, abstract, okay, of title. When you see in the school or state exam, abstract means summary. Abstract means summary. So link these two. Abstract means summary. Now, summary of what? Summary of title records. Yes. So instead of pulling everything in detail, an abstract just organizes everything in chronological order, right? That allows you to see immediately, okay, there's this lien, there's that lien, this is the owner, there's the taxes unpaid, there's the water unpaid, whatever. Everything is in order. Whatever was recorded against the property will be in order. Okay? So abstract, it's a summary of the title history. Okay? Abstract is a summary of the title history. All right, next page we have Torrens system. Torrens system, next page. Jose says it's like a driver license abstract. Absolutely. It gives you a brief history of all your tickets and suspensions and all that stuff. Yep. And cars you've owned, and when you register them, everything's there in your driver license abstract. Sorry? Nope. You didn't highlight what? Whatever's on recording. What is on recording? Oh, well, that's what I'm going over. Recording. All right, so the next page, we're talking about the Torrens system. This is one of the ways to record records. Okay. And in the Torrens system is not used in every state. Not many states actually use the Torrens system. But as it says here, certain states and counties use the Torrens system of recording. The Torrens system, as you guys see right here highlighted, the Torrens system differs from other title recording systems in that the title passes when the conveyance has been duly registered on the title certificate itself. So the best way I can explain as an example is when you buy a car, right? They give you a paper, and on one side is the title, on the other side it's the bill of sale to transfer, right? So whenever there's a transfer of title on the property, the Torrens system records onto that title itself, and that's the document you use for the next transfer. Okay? In other states, let me move on. In other states, we don't have those options. Like state of New Jersey, we don't use the Torrens system. We use the title searches, the abstract, attorney's opinion. We use the title insurance and a certificate of title, but we don't use Torrens. Okay. Now, since the value of a property is only as good as the marketability of its title, the evidence supporting the status of the title is a significant issue, right? To demonstrate marketable title to a buyer, the seller must show that the title is free of doubts, okay? Free of doubts about the identity of the current owner. So I have to be able to prove that you are who you say you are, that you're the owner of the property, that you're entitled to sell the property, right? That there is no defects, like we've been talking about. There's no defects such as erroneous legal description. So we know the property is this property, right? And not your neighbor's property. So sometimes even the survey might be of an issue here. We need to have a survey before we can give good title. Other claims that could affect the value, like mortgage company, contractor work, taxes unpaid, utility bills unpaid, and so on, or undisclosed or unacceptable encumbrances. What other encumbrances do you guys remember besides liens? Guys, make sure you're on camera. If you're not on camera, it does not count for your hours. Thank you for coming back, Suzanne, and Wendy, thank you for joining. All right. If I notice a broom in Amira and Monifa's background, you think I'm not going to notice that you guys jump around in rooms and, you know, disconnect your cameras? I see it all. I'm too much, I know. All right. So I'm still waiting. Melissa? What types of encumbrances do we have besides liens? Still waiting. Philip, easements. Okay, what type of easements? What is an easement? Since you're writing, since you're looking for it, I'm asking you guys to give it to me by heart, what you remember, right? Jogging your memory. So, go ahead. What's an easement? That's an encumbrance. Close. What's an easement? Got 6 people on YouTube. YouTube, you can answer as well. Philip, right to use someone else's property. Okay, great. What types of easements do we have? That's the bundle of rights. Easement by necessities. Thank you, Jose. What else? What type of easements do we have? Easement by necessity. What is it? A dominant. Okay. And servient. What type of easement is that one then? We got easement by prescription as well, easement in gross. There's one missing. The one that has to deal with, got party wall easements, okay? The one that has to deal with the dominant estate and the serving estate. Appurtenant, thank you very much for searching. All right, so Philip just gave me the last one. Easement appurtenant, when two properties are together. Very good. So easements, and it's the right to use someone else's property, Amira, correct. So those are easements. These are encumbrances, right? But there's under encumbrances, there are liens, easements, right? And there's something else. There's two more. Rob? What else we have? We got deed restrictions, not conditions, but close. Deed restrictions. What else? Types of encumbrances. Things that limit your property, or the value of your property, or the title of your property. Easements, deed restrictions, encumbrances, licenses. Thank you very much. What about that one that I told you that it's illegal? Like you putting a fence towards your neighbor's property, like you're leaning onto your neighbor's property or pushing towards your neighbor's property. Encroachment. Very good. All right, awesome. You will remember. Cucaracha? There you go. Roaches, they shouldn't be there. That's what Belinda says in the morning. The instructor in the morning says, encroachment, it's a weird word, but think of roaches. Shouldn't be there. That's it. They shouldn't be there. It's illegal. Yeah, no, I'm telling you, she's good. She's funny. All right. All right, cool. So we talked about undisclosed or unacceptable encumbrances. I think of football when I hear encroachment. All right, Phil. So when you hear encroachment for football, what does it mean in football? Or handball, because you really play with your hand. Okay. It means you're offside. That means you passed what? You passed the touchdown. No. The line of scrimmage. Very good. So you passed the boundary. Correct. Line of scrimmage or the boundary right there. So that's what it is. The same thing. Encroachment is when you go beyond where you're supposed to be. That's pretty much what it is. All right. So football, you can associate it to American football. Yes. I want to correct that because being Portuguese or European, we have football where you play with your foot. Here we have American football, which the only foot in it is the size of the thing, right? Right here they call soccer instead of football. Anyway, it's funny. I just like to have fun. All right, cool. Now, 4 principal forms of evidence that the owner can use to support his assurance. Guys, which document, before reading any further, pay attention to me, before reading any further, which document or documents prove or evidence title? Which documents prove or evidence title? Without reading, focus on me, don't read. Deed. Okay, let's see if that's what we get. Which document proves or evidences title? Let's see what everybody else says. Stop reading. That's cheating. I told you to tell me. Everybody starts reading. Jose says insurance. Okay. What evidences title? Which document evidences title? Amira says deed. Okay. Anybody else care to participate? If you're Googling, it's not there. To be signed? Not needed. The evidence of title does not need to be signed. Nope. But it's okay. A lot of people get this wrong. It's okay. My question was, you're trying to put it on Google to see what answer comes up? My question was, what type of document evidences or proves title? Siri does not prove title. Will does not prove title. Nope. Jose, you're an iPhone user, Jose A? You're fired. If you're an iPhone user, that's it. I'm not talking to you guys anymore. No Siri.
Oh, so
You can have Alexa. You can have Hey Google.
the title, your ID.
Even Cortana, but not Siri. Your ID is a proof of title? What title does it prove?
It means on the title. Your ID.
The deed is not evidence of title. Guys, write this down somewhere. These are the only 4 types of evidence of title. The deed proves that a transfer existed. Write this down. The deed proves that a transfer existed. The deed is not evidence of title. The deed is not evidence of title. Because I already told you, I can sell you my phone. I'm claiming it's my phone, but you don't know if it's my phone. Right? So selling it to you and putting it on paper simply says that a transfer happened. A deed is not evidence of title. Write that down somewhere. The deed only proves that transfer occurred, that transfer happened. That's all. Okay? So what evidences do we have? What is evidence of title? We have the Torrens certificate, the title insurance policy, an attorney's opinion of title abstract, and the title certificate. These are the 4 evidences of title. Okay, don't worry.
Sorry.
I said we don't use in New Jersey. Yep. Actually, Torrens certificate, I told you, similar to the car title. When you buy a car, on one side is the title record, the other side is the bill of sale. Right here, I highlighted, but you don't have to highlight. It's just for me to show you something. It says, if available, the Torrens certificate is the best evidence for the reasons given earlier. Like I said before, it's not merely a record. The Torrens system is the title itself. Okay? Only because of this. In New Jersey, for instance, we use title insurance or we use the certificate of title, right? So, but Torrens system is not the same. That's why I'm trying to tell you that in New Jersey, for instance, we use this. But what is title in other states that don't use the Torrens system? What is title? Title is just a search of a bunch of records of the deed, of the mortgage, of liens and other encumbrances against the property. Okay, that's what a title will be. It's the combination of things. So the deed is not evidence of title. It's the search of all these documents that comprise the title. In a place where the Torrens system is used, all these records are going to be attached to the Torrens system. That's the certificate itself. So that's the title itself. It's one document that you carry everywhere, and it's always up to date. I don't know if you guys remember back in the day when you had, now we have bank statements, right? But before, we used to have a little booklet, and you had to enter every single, like a balance sheet. You had to enter every single transaction you did, right? I don't know how it was here, but in Portugal, for instance, we would bring that document, slide it into the ATM slot, and it would update with all the transfers, right? So everything is recorded into that document itself. That's a Torrens system. Everything is there. Your name as the owner and all the transactions that happened. Does that make sense? Where in New Jersey, we have a deed, it's a separate document, mortgage, a separate document, right over there as well, but in those states, but it all separate documents, and we have to do, hold on, and we have to do a separate search, okay, every single time. There's not one document you pull out and say, hey, everything's here. No, that is not with you. It doesn't. Everything is there. No, we have to do a title search every single time. That's what it is. That's a memo. No, I'm talking about a balance sheet where you entered today I paid $50. Tomorrow, here's another entry of $25. Here's another entry of whatever. A balance sheet is like today your bank statement that shows all your transactions. So the Torrens system, Wendy, passbook. There you go. Thank you. So the Torrens system is like that. Shows all the items, and it's something you have. Versus what we have in New Jersey is a title search, and after doing the title search, if everything's okay, there's a title company that will insure it. They checked it, looks good, insurance. All right? It's evidence of title. That's it. But it's not the same as anything else. Okay? It's types of evidence of title. Dahlia, the deed is only like a shopping receipt. That's right. I went to buy something. I got the receipt. It's mine. That's all. It does not prove that the supermarket had the right to sell it in the first place. That's it. For us to know if the supermarket had the right to sell me something, we need to go see their books. And then whoever sold it to them, we need to go see those books. That's a title search. Okay? So if everything is okay, the title insurance policy is commonly accepted as the best evidence of marketable title, only because somebody's willing to insure and pay if something is wrong. Okay? At the bottom of that page, it says standard coverage protects against title defects, such as incompetent grantors. What is an incompetent grantor? Somebody that was not of sound mind, or someone that was not of age. They were not adults. So they're incompetent grantors. Okay? Invalid deeds. Fraudulent transactions. If I sold something to you that was not mine to sell, right? The current owner now is protected because they had insurance. Right? Defects in the chain of title and so on. Extended coverage of title insurance protects against liabilities that may not be of public record, including fraud, unrecorded ownership claims, unintentional recording errors, and unrecorded liens. And I'm skipping some stuff just so I can go straight to the point with title evidence, okay? Still review it later. Before issuing a title insurance, like I said, the title company pulls the records. It's going to look at it, put everything in chronological order, and if everything looks fine, they will issue a commitment or a binder. Okay? A commitment or a binder that says, we will insure you if everything here is true. Okay? Another type of evidence of title is either the attorney's opinion of title or the title certificate right here. Okay? Attorney's opinion of title or title certificate. Now, the attorney's opinion of title is pretty much, it's not an insurance. Okay? It's the attorney had an abstract company pull the title. The attorney looked at it, similar to the insurance, looked at it and said, appears to be okay. Right? The question now is, what is the problem with opinions? That's my question. What is the problem with an opinion? Anybody? It's never legit? Okay, so it's not being legit. What is it? It's not guaranteed. It varies, right? It's not, it could be legit. It's just everybody has their own point of view, right? It's not guaranteed. It varies. Now, but opinion, like if I tell you today was a wonderful day, it's a matter of opinion. For me, maybe it was a wonderful day, right? That opinion does not affect anybody. Me saying that it was a wonderful day, how does that affect you? It doesn't, right? Now, if an attorney says that the title is good, and that's their legal opinion, and later on it's not good, comes back to whom? To the attorney. All right, so that's one of the issues, guys. Hey, Wendy, decide yourself. You're on YouTube, you're on Zoom. You're on both sides? All right, so like I was saying, a legal opinion or professional opinion is like us, guys. If you give an opinion on something and it's a professional opinion and it's wrong, you could get sued, right? So that's the problem with the attorney abstract or opinion of abstract title. So they search it, they look at it, they give an okay, but there's no guarantee to the buyer. And if something is wrong, they can, if it's defective, they can sue the attorney. The next one is a title certificate. Now, it says here the title certificate is a summary of the condition of title to the date as of the date of the certificate. It's based on search of public records by an abstract or title analyst. The certificate does not guarantee clear title against defects, unrecorded encumbrances, or encroachments. So, this is the weakest of all type of evidences of title. In fact, the title attorney, that's a verbal opinion. Okay, it could be in writing, but majority of the times it's a verbal opinion. Usually is used in rural areas, so farmland, right, where there's not many records available. Okay, just land. Yep, that's it. Monifa, you didn't have to hide that Amira had left and came back and went for a tour and all that stuff. I see it. Right? I already discounted 10 minutes off her hours. That's it. She's like, let me turn the camera. You forget she has to be on the other camera?
That's best when it's not much details to apply. In other words, land.
It's not that it's best, it's just there's no alternative. Maybe there's no actual records to pull. Or the records have been there for hundreds of years. Could be.
So between attorney's opinion and certificate, which one is the best then, since they're both
Look, it's not about being the best, is what's used, right? But if we were looking at the strongest one, it's by this order. The strongest one would have been the Torrens certificate. The second strongest one, so in New Jersey is the strongest one, is title insurance. Right? Then it would be attorney's opinion of the abstract, and the other one is just the abstract, or just an opinion. There's no guarantee in these last two. In the title insurance, there is a guarantee because if something is wrong, unless it was fraud, the insurance company is going to cover it. In the Torrens system, right? There's no ifs or buts about it because you have the records right there. Every single transaction. Okay? So, Jose, I think I just answered that. This will be the worst one. And Monifa and Amira. And Monifa and Amira say bathroom break. I didn't give nobody no bathroom break. I gave you 10 minutes before and you said it was good. I gave you more than 10 minutes. How many bathroom breaks do you need? I'm here. All right, I'll give you a permanent bathroom break. How about that? Permanent until Monday. You couldn't have waited just another 10 minutes. All right, guys. So we are done. If you have any questions, guys, reach out to me over the next few days. Make sure you study. Go over the Quizlets in the student portal. Go over the class replays in the student portal. Test yourself in the student portal. There's a lot of goodies for you over there. So take advantage of it, please. And if you have questions, the group chat on WhatsApp is very helpful. When you ask a question, either me or some of the other students is going to help you answer that question. Okay? All right, guys. Have a good rest of your week. See you Monday.